Hello, this is Matt on the Moon Lambo channel. It has finally happened. The Chamber of Digital Commerce has filed an amicus brief in the SEC v. Ripple case. So they're a party not associated with Ripple, obviously, and also not even in support of Ripple. And to some of you, I don't know if that sounds bad on the surface. There are a number of people within our community who are just detesting their perception, which I'd say is an accurate perception, that the Chamber of Digital Commerce isn't really siding with Ripple. But this is a fantastic brief, by and large. There's some critique, sure. There's always critiques to be had on pretty much anything in life. This is fantastic, and I'll just tell you this at the outset. It's not John Deaton or the Chamber of Digital Commerce's job to be lawyers or supportive of Ripple specifically. Both John Deaton as well as the Chamber of Digital Commerce, in terms of being friends of the court, they're there to add perspective from an outside source. In fact, I'll go take it a step further. If the Chamber of Digital Commerce was explicitly supportive of Ripple and not just adding clarity specifically surrounding the digital asset class and cryptocurrencies, blockchain technology, and XRP, if it were outside of that and it were really more so just focused on supporting Ripple, I don't think that would fly with the judge, to be honest with you, because that's not the point. Ripple can defend themselves, and so we really shouldn't expect that the Chamber of Digital Commerce is going to support Ripple, but who the hell cares? When you see what's in here, I think you're going to be very happy. For those of you that haven't read it, I tell you what, I don't know if you can hear this, I got some dead trees that have been my little Moon Lambo fingers here, and I read this whole thing. That it was 27 pages, although, the meat and potatoes of it was basically like 12 or 13 pages. So what I did was I highlighted the parts that I found most interesting. I did make a few notes that I didn't forget, a few key things, and I'm going to share with you the specifics. To kick the video off, I'll do what I typically do in videos where I cover legal stuff. I'm going to share with you opinions of attorneys within the community, specifically attorney John Deaton. Got comments from him on this, as well as attorney Jeremy Hogan. And then for those of you who are super duper interested on what the Chamber of Digital Commerce explicitly said in greater detail, I'm going to break it down and I'll explain why this approach, while not supportive of Ripple, and in fact acknowledging there's a possibility that early sales of XRP could have been unregistered securities transactions, investment contracts specifically, while acknowledging perhaps that's the case, what they state in here is a powerful defense of basically everything that attorney John Deaton has been articulating for over a year and a half at this point. It's good stuff. And even John Deaton acknowledges, hey, look, if the SEC had just filed, against the SEC and they were very narrowed examples of sales of XRP that they want to see were securities transactions, John Deaton says, even I wouldn't have jumped in this thing. So it seems to be a very similar approach. So that's just my perspective. But before breaking this down any further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice. And you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. Shout out and credit to James K. Filan, who is an attorney within the XRP community. He shared this information this morning. And this is Perianne Boring, who is the founder of the Chamber of Digital Commerce. And it's actually been around for a pretty damn long time. Founded in 2014, so it's existed most of the time that crypto has existed. And while, as I mentioned in a recent video, I have a suspicion that she and anybody else at the Chamber isn't exactly necessarily wild about XRP and or Ripple, they're stepping up. They're definitely stepping up because they understand if things don't go well for XRP, then crypto could just be devastated, specifically in the United States by the SEC. So it wouldn't be just XRP. That much they understand, and they make broader arguments in terms of what makes sense from a legal perspective as it pertains to Howey and some other stuff here. So here is what attorney John Deaton had to say upon reading this, finding out that it was released. He actually had, at this point when he was tweeting this out this morning, he hadn't yet gone through the whole thing, but he said the following. I haven't had time to fully read the Chamber of Digital Commerce and Perianne Boring's amicus brief, but I'm getting tagged in a lot of comments about it. Please know, as amicus counsel for XRP holders, I welcome the brief. The importance of this case cannot be overstated. We need the judge to truly appreciate the magnitude of her decision. The SEC is stretching the application of Howey into secondary market sales, calling the underlying asset XRP a security. The more who call the SEC out, the better. So yes, he's hitting the nail on the head as per usual. And the Chamber of Digital Commerce definitely comes through loud and clear here. So it's good to have another entity that on their own is like, oh yes, we would really like to be able to speak our mind in this case. Here's our amicus brief. And in terms of what John Deaton cited right there, this idea that secondary sales of XRP, secondary markets, are somehow also unrestricted security transactions. For those of you that are going to stick around for the breakdown of this, the degree to which it's so clearly, plainly articulated how that's illogical, I don't know how to state sufficiently right now how it's powerful. You're just going to have to experience what this is. But that's why I keep thinking, to anybody who's unbiased with half a brain, and I think that's certainly Judge has a full brain, okay? Judge Torres here. In considering all this information, I don't know how she could possibly come to the conclusion that the SEC's argument on this topic is even coherent. It is incoherent. Then there was this from attorney Jeremy Hogan. The Chamber of Digital Commerce's amicus brief is very helpful for Ripple. I wasn't expecting this, to be honest. Part 1 was confusing, but arguments 2 and 3 are really good, and the Chamber's disinterest in Ripple brings a lot of credibility to the brief. See, and that's why I'm with Attorney Hogan here. That's a positive. There's some people that were kind of upset that, you know, it's not more so in defense of Ripple, which is one developer building on top of the XRP ledger. I'm like, that's not what the case is about for us. Yeah, I mean, yes, I'm a fan of Ripple, but damn, as long as XRP can be openly, legally traded in secondary markets in the United States, like that should be the thrust of what we're getting at here, right? To claim that the underlying asset itself is no. And so there were these 3 sections, and number 1, I'm actually not even going to read it at all. So it was interesting. Upon reading Attorney Hogan's tweet here, and this, when I first read his tweet here, that was before I had read for myself this amicus brief, and reading Jeremy Hogan say, part 1 out of the three parts, part 1 was confusing. I was like, I wonder why it's so confusing. And upon reading it myself, I'll just say this. I would have characterized it slightly different, but he's coming from, at a legal perspective, and for me, I'm just like the lay person here. But I will tell you, to me, it just seemed like they were describing the Howey test, effectively. I read through that thing, and I'm just like, this isn't even, it's not really an argument even. They're just like describing the Howey test. So, unless they perceive that as necessary to make sure that everybody's on the same page for the subsequent arguments, okay. But to call number 1 an argument, it didn't really seem like much of an argument to me. So I take issue with that. But that's the worst critique I have of this whole thing, to be honest with you. Part 2 and 3, very powerful. You're going to love it. But Jeremy Hogan had a bit more to say first before we jump into it. Jeremy Hogan said, the Chamber is very precise in its, quote, the asset itself is not a security argument, end quote. But look at the bonus, pointing out that SEC guidance says the asset itself is not a security, but SEC enforcement stated the exact opposite. Maybe John D. knows what he's doing after all. Smiley face. Ain't that the truth? And then he says, and finally, the Chamber discusses how there is no authority to suggest that secondary sales can be considered part of an investment contract. It's an important point for Ripple as pertains to potential damages if early sales are deemed an investment contract. Good start. So now let's really dig into the meat of this here. Let me just start flipping through and... yeah, I'm going to get a little bit further, because the first X number of pages, it wasn't even the actual amicus brief. It was other stuff, like motion to file the amicus brief and all this stuff. So we actually have to jump to, I think, to page 5 here. Yeah, let me scroll down here. But yeah, but really, again, like I said, so the first argument, if you look at it, and where's the page? Oh, yeah, almost there. The first argument, like I said, it really does just appear to be a description of the Howey test. So here's what it was called. Here's argument 1, and this is what, I'm not going to read this section at all, but this argument was titled, legal precedent provides that the Howey test should be applied to determine if the initial offering of a digital asset is an investment contract. Okay, well, that's true, but nobody's arguing that it shouldn't be, actually. So that's why, for me, upon reading this, I was just like, they're just describing stuff that isn't really, controversial at this point. Not that I could see, anyway. So then we get down to the really good stuff, though, which starts, as I said, on page 5. And this is section 2, which is titled, and let me flip to this here on my paper. I'm trying to, for those of you looking at the screen, I've got it on the screen, too, because I know some of you like to follow along like that. But I'm going to be looking at my paper here. So section 2 is titled, it is well settled that the subject of an investment contract is not itself a security. As discussed above, Howey provides that an investment contract for purposes of the Securities Act means a contract, transaction, or scheme. Accordingly, the subject of such a contract, transaction, or scheme is not necessarily on its own a security. This is true whether the subject of an investment contract is a physical asset or an intangible one, such as a digital asset. So let's pause a note here. The scheme being separate from the subject is the same as saying that oranges exist and they're part of the Howey contract, but it doesn't mean that by the nature of them existing, them being the subject of it, that doesn't mean that is like oranges are a security forever or applied to the SEC v. Ripple case. Same concept here. Even if there were transactions of investment contracts, of specific sales, that doesn't mean the underlying asset is, XRP in that case would be a security as a result. So that's effectively what they're getting at. And then they state a little bit lower, right around here, remarks at the Yahoo Finance All Market Summit, crypto, which is June 14th, 2018, so that's the Billy Boy Hinman Ethereum Free Pass speech date. Investment contracts can be made out of virtually any asset, including virtual assets. The Hinman speech. In each of these examples, the subject of an investment contract is a commodity with its own properties and inherent value separate from the investment contract. Beavers can be used for their pelts. Oranges can be eaten, and condominiums can be lived in. Similarly, a digital asset can have its own value as an asset to pay transaction fees and use applications on a digital assets network. Thus, just like oranges in Howey would not themselves be securities if the oranges were grown and sold at a farmer's market, the subject of an investment contract should be evaluated separately from the investment contract itself. So pause. Doesn't that sound like it could have just been written by Attorney John Deaton? And that's why I keep saying, everybody on the damn planet that comes in unbiased and has at least half a brain is going to come to the same conclusion, that the SEC is just full of it. And they make contradictory statements against themselves. On the reg, my friends. They're hypocrites. They're just trying to win. That's why they got called out by Judge Knepper literally as hypocrites and as people who are not acting in good faith in accordance with the law. And I'm paraphrasing a bit there, but that's what Judge Knepper actually said. Scathing rebuke of what they'd said. Anyway, this Chamber of Digital Commerce then continues. Although the Howey test is intentionally a flexible standard, it is not all-encompassing. Indeed, guidance from the SEC staff suggests that certain transactions in a given digital asset are simply technology transactions and therefore not securities transactions. The federal securities laws favor substance over form, and the U.S. Supreme Court has placed emphasis on the economic reality of a situation. Digital assets are simply electronic records which contain data that can represent anything. For example, some digital assets clearly represent securities such as tokenized stocks and bonds, while others are ledger entries that can be traded back and forth through technology transactions on a network as commodities, i.e. bitcoins. The essential character of a stock as a security is not changed merely because it is represented by a paper certificate as opposed to an electronic record. As such, the use of a particular technology does not and should not change the economic substance of the underlying asset. So let's pause to note here, and that's all obviously true. So even though it's not the case that the Chamber of Digital Commerce is here to protect or fight on behalf of Ripple, which I think is a good thing, frankly, and obviously Attorney Hogan stated the same thing. Even though that's true, this is still positive for Ripple, because even if they're found to have sold XRP as an investment contract, certain specific early transactions, what Ripple mostly cares about, because they'll write a check, they don't freaking care, you know that, they have more money than God. What they care about is being able to use XRP in the United States and be able to manage that liquidity moving forward. That's what actually matters to them. So in a roundabout way, it is good what's being done here by the Chamber of Digital Commerce. It actually is indirectly good for Ripple. It's just that the Chamber of Digital Commerce, they're not saying any of this because they care about Ripple. That's what I'm getting at here, and that's the distinction I wanted to make there. All right, and then where did I just leave off? Shoot, I hate it when I lose my spot here. I don't think did I read this part here? I apologize if I'm rereading. Let me just start going through it, and even if I do reread it again, it'll just help the flow continue. So here we go. As this court has noted, digital assets are a lawful means of storing or transferring value and may fluctuate in value as any commodity would. In the abstract, I didn't read this. In the abstract, an investment of money in a cryptocurrency utilized by members of a decentralized community connected via blockchain technology, which itself is administered by this community of users rather than by a common enterprise, is not likely to be deemed a security under the familiar test laid out in SEC v. WJ Howie Co. So it's pause and note. They're going back to what the actual law was as a result of the 1946 Howie case, which went all, again, that's the Supreme Court we're talking about here. That's where this was decided. That distinction was made back then. Today, the SEC is pretending as though that distinction doesn't exist because they just want to win because they're terrible monsters. Anyway, Chamber of Digital Commerce continues. I'll make sure I didn't miss anything. Yeah, there we go. Okay. The court declined the opportunity in Telegram to opine on whether the subject of an investment contract is distinct from the investment contract status as a security. And instead, this court focused its decision on the scheme in its entirety, as opposed to opining on the characterization of its underlying asset. On this point, we urge the court to make clear that the status of the subject of an investment contract is a separate inquiry from the status of the investment contract itself. Bam, exactly. And that is something that was supremely missing in the SEC v. Telegram case. That clear distinction that we keep talking about, and they're just nailing it with pure logic right here. And fortunately, really, it's unfortunate it was missing in the Telegram case, because so they focused on the scheme, as it were, while kicking the can down the road in terms of addressing, okay, what about the underlying asset? What do we have to say here? What do we have to say here? Because the token XRP is not a security purely because it exists. And so here's the Chamber of Digital Commerce saying, please, judge, when it comes down to this, please make a distinction between an investment contract and the subject of the investment contract itself, which in this case, SEC v. Ripple, is XRP. These are different things. Couldn't be more obvious. Could not be more freaking obvious. Now this brings us to argument number 3, titled, "The Law is Unsettled as to Secondary Transactions of Digital Assets." Because the investment contract analysis focuses on the investment transactions and not the underlying asset, the regulatory characterization of different transactions in a particular digital asset may change as related facts and circumstances change. For instance, the original sale of the land and trees in Howie constituted an investment contract when placed in context with W.J. Howie's management services. However, if those same plots of land and orange trees were then resold later, separate from W.J. Howie's services, such sales may no longer constitute investment contracts. There you go. And this is the reason this argument is important, is because when you recognize that people are buying and selling XRP separate from XRP on a global scale, if you compare that back to the Howie case, use the logic there, it rips it apart. Secondary XRP sales clearly are not sales of unregistered securities, and the Chamber of Digital Commerce breaks that SEC argument with pure logic and common sense. Because again, think about it. Even though the Supreme Court, 1946, did find that the totality of the scheme with the oranges and the orange groves and all that did invest in, it was an investment contract, it doesn't mean that, in the future, the land could not be sold anytime, for the rest of eternity, anytime the land is sold, which includes the trees on it, even if it has nothing to do with that scheme, that's now somehow part of that investment contract. You see how that logic falls apart? So an orange tree, once part of a scheme, is now, by the nature of it existing, an investment contract forever? That's a piss poor argument. This is why, again, I'll say for like the third or fourth time in this video, anybody who looks at the facts and circumstances, who is unbiased and has at least half a brain, will come to the same conclusion. There's no other way to look at this. Not if you're being intellectually honest. Moving on. Indeed, the dynamic nature of the Howie analysis makes it a particularly challenging framework to apply to secondary transactions involving fast-moving and ever-changing technology businesses, especially those that incorporate the native digital asset essential to the operation of the blockchain network. And that is so true. So let's pause and note, that's true, and the SEC needs to explain what constitutes a common enterprise in the context of decentralization. That's a key piece of what they're missing right here. Because the degree to which something is decentralized is it's directly tied to whether or not there is a common enterprise. And whether or not there is a common enterprise is a gigantic part. It's one of the prongs of the Howey test in determining whether or not what's being analyzed is an investment contract. We don't have that clarity here. Anyway, Chamber continues and says, the lack of clarity regarding secondary transactions in digital assets also impacts the blockchain industry as a whole and potentially the broader U.S. economy. In this case, all parties have commented on, and the court has taken notice of, the recent public statements of two SEC commissioners that, quote, there is a decided lack of clarity for market participants around the application of the securities laws to digital assets and their trading, end quote. So obviously you know that Hester Peirce and Elad Roisman in particular, they aren't having what the rest of the commission's having, right? They are not okay with this idea that there's actually regulatory clarity specifically from the SEC. And they've articulated that, and now, because they did that and they were intellectually honest, it harms the SEC's case. But they did the right thing. And then a little bit lower on that page, it reads as follows, right around here. Okay. A number of market participants have approached the SEC without success, requesting interpretive relief or rule-based guidance on the legal standard to apply for secondary transactions in digital assets that were previously the subject of an investment contract. In the instant case, the SEC has stated that it, quote, does not typically decide whether any particular financial instrument, without additional context, qualifies as a security per se, end quote. Now, declining to answer defendants' interrogatory whether the SEC considers Bitcoin and Ether to be securities. The SEC has argued that it does not claim that XRP is itself a security, but rather that XRP, quote, even in the secondary market, is the embodiment of those facts, circumstances, promises, and expectations surrounding the digital asset and the manner in which it is offered and sold, and today represents that investment contract, end quote. This application of the investment contract analysis to digital assets, like digital assets themselves, remains novel. So let's pause to note. Saying that it remains novel, it's perfectly in line with what Attorney Deaton has stated, which is, you know, and John Deaton was a bit more forward and blunt with it, which is perfectly fair. He stated that this goes against precedent that, frankly, has been set. You know, it just, and again, I know it's frustrating for us because it couldn't be more obvious this is indeed the case, but the chamber here is arguing the same thing that Attorney John Deaton is arguing, just using slightly different words. It's the same concept here. But my gosh, the idea that because something is traded on a secondary market, that represents something that is actually completely unrelated is a completely absurd argument. And then the chamber says, we are not aware of any judicial decisions that have correctly applied Howey at the time of an initial sale and then reapplied Howey to later secondary transactions involving the same underlying asset. That, however, is the approach that the SEC suggests is correct. There you go. That's exactly correct. There is no case law whatsoever to indicate that this approach has any sort of precedent or legal backing. It does not. And here the chamber is politely acknowledging that. And Attorney Deaton has recognized the same damn thing. There is no legal precedent for this. The SEC is just asserting things. They're saying, okay, well, XRP, is investment contract to when Ripple's selling that XRP, and now if you look at what's happening more broadly globally, that's also an investment contract, right? All those secondary sales. There's no precedent, there is no case law to indicate that it's remotely reasonable to come to such a conclusion. There is nothing that the SEC themselves can point to come to that conclusion. Then we got, let me go a little bit further, going down to page 10. And I start in right about here. It cannot be that an asset that is the subject of an investment contract will forever embody the investment contract itself, as the SEC now suggests, without citing legal precedent for that conclusion. Otherwise, purchases of certain casks of whiskey families of beavers, and orange trees would be subject to the securities laws, which has never been the case under the existing precedent. Let's pause. That's exactly what Attorney Deaton's been getting at. There is no precedent. That's what I was harping on just a minute ago. And then the chamber says, on the other hand, it remains extremely difficult to discern when digital assets may be used and traded without each purchaser entering into an investment contract. Without express regulation, the market has had to rely on highly fact-specific district court decisions, settled administrative enforcement actions, and non-binding guidance and personal public statements made by SEC staff and commissioners, some of which were expressed views that have changed with each new appointment to the commission. The lack of legal precision inherent in many speeches, along with contradictory statements made by various federal regulators, has created a significant and unprecedented degree of confusion for the U.S. blockchain industry. Bravo. Folks, this is the same stuff we've been screaming for over a year and a half now. It's nice to see it from somebody else. And again, having this additional party here, in addition to what John is doing as Amicus, this is powerful. You got this, you got over 72,000 XRP holders all screaming, no, the SEC is wrong. Hey, no, Judge, please. It adds additional weight to the seriousness of the situation. And then if you go to page 12 here, towards the top. Yeah, I'm starting right here. It reads as follows. The Chamber believes that, as long as the underlying asset does not include financial interests, such as legal rights to debt or equity, digital assets are presumed to be commodities. There you go. And so there you go. They don't give a damn about Ripple specifically, but I don't care that they don't care, and that strengthens their case. So while some people were detesting that in the community, I understand why, and I respect your opinion. I just disagree. To me, it makes all the sense in the world to take the... And on top of that, I get the sense they really don't care about Ripple. I don't even think they really care about XRP. That's just a suspicion, so I can't back that. But it's just the way in which they've seemed apathetic for almost the entirety of the time that this lawsuit's been going on. It's just like, you're the chamber, and you're not even like... And then they're making up nonsense. Like Perry Ann was even saying, well, we haven't filed the Amicus brief. We really can't comment. Well, that's not true. You could have. You just didn't want to. Okay? So either way, though, it doesn't matter to me if they do or don't like XRP. The bottom line is this helps the entire world of crypto, including the XRP community. This is a big net plus. Couldn't be more obvious. And then I'm not going to read this, but I'll put the conclusion on their page. It really is just reiterating everything that they already said, so I feel like I'd be a bit redundant to conclude it. I mean, sometimes with their specifically witty or well-worded comments in the conclusion, even if it just reiterates what's already been said, which is the purpose of a conclusion, I guess, then sometimes I read those when I cover this stuff. But in this case, I just like, no, it's good. It's well written, but nothing stands out that's going to be markedly different than what I already shared with you. So I thought this would be a good point to wrap up. But I hope you guys are feeling good about this. Let me know what you think in the comment section below. I'm very eager to see what y'all have to say about this. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.